The Senate will come to order. Senator Zenzinger will lead us in the pledge.
Thank you, Madam President. Colleagues and guests, if you'll please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Good morning. Mr. Majors, would you please take the roll?
Aguilar, Balmer, Baumgartner, Brophy, Cadman, Crowder, Grantham, Guzman, Harvey, Heath, Herpin, Hill, Hodge, John, Johnston, Jones, Kafalis, Kerr, King, Lambert, Lundberg, Marble, Newell, Nicholson, Renfro, Rivera, Roberts, Scheffel, Schwartz, Stedman, Tocktrop, Todd, Ulibarri, Zenzinger. Madam President.
Here. With 35 present, 0 absent, 0 excused, the Senate has a quorum. Motion to adopt the journal. Senator Marble.
Good morning, Madam President. I move that the reading of the journal dated Wednesday, March 26, be dispensed with as approved and corrected by our most amazing secretary.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The motion is adopted. Committee reports.
March 26, 2014, Committee on Agriculture, Natural Resources, and Energy. After consideration of the merits, the committee recommends the following: House Bill 1267 be referred to the Committee of the Whole with favorable recommendation. March 26, 2014, Committee on Judiciary. After consideration of the merits, the committee recommends the following: Senate Bill 163 be amended as follows and as so amended be referred to the Committee of the Whole with favorable recommendation, with the recommendation be placed on the consent calendar. March 26, 2014, Committee on Judiciary. After consideration of the merits, the committee recommends the following: House Bill 1141 be amended as follows and as so amended be referred to the Committee of the Whole with favorable recommendation and with the recommendation that it be placed on the consent calendar. March 26, 2014, Committee on Education. After consideration of the merits, the committee recommends the following: Senate Bill 165 be referred to the Committee of the Whole with favorable recommendation. March 26, 2014, Committee on Health and Human Services. After consideration on the merits, the committee recommends the following: Senate Bill 160 be referred to the Committee of the Whole with favorable recommendation with the recommendation that it be placed on the consent calendar. March 26, 2014, Committee on Health and Human Services. After consideration, the Mayor's Committee recommends the following: House Bill 1257 be postponed indefinitely. March 26, 2014, Committee on Health and Human Services. After consideration, the Mayor's Committee recommends the following: House Bill 1207 be referred favorably to the Committee on Finance. March 26, 2014, Committee on Business, Labor, and Technology. After consideration, the Mayor's Committee recommends the following: House Bill 1185 be referred favorably to the Committee on Appropriations.
Senate Services.
March 27, 2014, correctly revised House Bills 1186 and 1277, correctly re-revised House Bills 1136 and 1271, correctly enrolled Senate Bills 22, 58, and 98, Senate Joint Resolutions 11 and 20.
Message from the House.
March 26, 2014, Madam President, the House has passed on third reading and transmitted the advisory statutes House Bill 1289. The House has passed on third reading and transmitted the advisory statutes House Bill 1187 as amended. The House has passed on third reading and transmitted the advisory statutes Senate Bill 131 as amended. The House has adopted and returns herewith House Joint Resolution 1014.
Message from the Reviser.
March 26, 2014, we herewith transmit without comment House Bill 1289, without comment as amended, House Bill 1187, without comment as amended, Senate Bill 131.
Introduction of resolutions.
Senate Joint Resolution 23 by Senator Lundberg and Representatives Sane and Wright concerning an application to the United States Congress for an Article 5 Constitutional Convention of the States for proposing amendments to the United States Constitution that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress.
State Veterans and Military Affairs. Introduction of bills.
Senate Bill 170 by Senators Todd and King and Representatives Kraftharp and Quorum concerning the authority of a vehicle that is being used to escort a funeral.
Judiciary.
Senate Bill 171 by Senators Schwartz and Jones and Representative Tyler concerning the ability of the Colorado New Energy Improvement District to arrange financing for water conservation fixtures.
Agriculture, Natural Resources, and Energy.
House Bill 1216 by Representative Sonnenberg and Senator Brophy concerning required safety markings for certain towers over 50 feet in height that are located in unincorporated areas of the state.
Agriculture, Natural Resources, and Energy.
House Bill 1286 by Representative Melton and Senator Stedman concerning authorization for the state treasurer to loan to the State Historical Society for public display items presented to the governor as gifts to the state.
Education.
House Bill 1288 by Representative Pabon and Senator Aguilar concerning personal belief exemptions to immunization requirements for children prior to attending school.
State Veterans and Military Affairs.
House Bill 1295 by Representative McCain and Senator Ulibarri concerning residential mortgage foreclosures and in connection therewith requiring a single point of contact and prohibiting dual tracking.
Judiciary.
House Bill 1312 by Representative Williams and Senator Ulibarri concerning efforts to reduce the number of foreclosures in Colorado and in connection therewith continuing the foreclosure deferment program.
Judiciary. Third reading of bills. Mr. Majors, would you please read the title to Senate Bill 156?
Senate Bill 156 by Senators Kafalis and Heath and Representative Lee concerning a requirement that a public benefit corporation file an annual report.
Senator Kafalis.
Thank you, Madam President. Good morning, colleagues. I move Senate Bill 156 on third reading and final passage.
Is there any discussion? Question for the body is the adoption of Senate Bill 156. Are there any no votes? Senators Balmer, Hill, Marble, Lundberg, Herpin, Harvey, Brophy, Lambert, Baumgartner, Renfro. Senator Brophy, I got you. With 25 ayes, 10 noes, 0 absent, and 0 excused, Senate Bill 156 is adopted. Co-sponsors. Mr. Majors, would you please read the title to House Bill 1186?
House Bill 1186 by Representative Schaefer and Senator Aguilar concerning the release of medical records to a person other than the patient and in connection therewith setting reasonable fees to be paid for the release of the medical records.
Senator Aguilar.
Thank you, Madam President. I move for the adoption of House Bill 1186 on third reading and final passage and ask for an aye vote.
Any discussion? Question is the adoption of House Bill 1186. Are there any no votes? Senator Hill, Senators Marble, Baumgartner, Lundberg, Harvey, Renfro, Grantham, Rivera, Lambert. With 26 Senators Shuffle, Mr. Minority Leader. Now it's balanced. All righty. With 24 ayes, 11 noes, 0 absent, and 0 excused, House Bill 1186 is adopted. Co-sponsors. Senator Nicholson. Mr. Majors, would you please read the title to House Bill 1277?
House Bill 1277 by Representative Melton and Senator Todd concerning eligibility requirements for recipients of grants from the Military Family Relief Fund.
Senator Todd.
Thank you, Madam President. Good morning, colleagues. I move the House Bill 1277 on third reading and final passage and ask for an aye vote.
Any discussion? Question is the adoption of House Bill 1277. Are there any no votes? With 35 ayes, 0 no, 0 absent, and 0 excused, House Bill 1277 is adopted. Co-sponsors. Senators Newell, Nicholson, Kafalas, Madam President Pro Tem. Senators Aguilar, Kerr, Mr. Majority Leader. Senators Crowder, Schwartz, Herpin, Toctrop, Johnston, King, Rivera, Roberts, Zenzinger, Jones, Ulibarri, Hodge, Hill, please add the President. Mr. Majority Leader.
Just want to make sure we're in the... Thank you, Madam President. I request that House Bill 1100 be removed from today's consent calendar and placed at the end of today's general order second reading of bills calendar.
House Bill 1100 will be removed from consent and placed at the end of today's general orders calendar. General orders, second reading of bills. Senator Hodge. You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The Senate will resolve itself into a committee of the whole for purpose of considering general order, second reading of bills calendar, and Senator Hodge will take the chair.
The committee will come to order. The court rule is relaxed. Mr. Majors, would you please read the title to Senate Bill 158?
Senate Bill 158 by Senators Stedman and Jones, Representative Hollinghorst, considering the harmonization of statutory recall election provisions with the recall provisions in the state constitution to reflect the manner in which contemporary elections are conducted, and in connection therewith aligning circulatory regulation and petition requirements with initiative and referendum circulator and petition requirements.
Senator Stedman.
Thank you, Madam Chair. I move Senate Bill 158. And I move the report of the Committee on State, Veterans, and Military Affairs.
To the State Veterans and Military Affairs Committee report, please.
Thank you, Madam Chair. The committee report addresses two provisions in the bill, essentially. It changes some wording to change the word completely to fully. This was suggested for consistency and clarity in how we describe a legal matter that has been fully adjudicated. And also strikes a provision at the back of the bill having to do with the situation that may occur when someone who is petitioned onto the ballot as a successor candidate and there is a recall of the incumbent and the successor is elected, and yet it turns out there were technical flaws in their petitions that they used to petition their name onto the ballot as a successor candidate. There's a provision that explains what happens in those eventualities if that were to occur, and we are referencing the language in the state constitution and in Part 2 of Article 12 of Title I for what happens when there's a vacancy that occurs because of that, and pointing to those existing provisions in law for how that situation would be handled in the remote possibility that fact pattern ever came about. Ask for an aye vote on the committee report.
Further discussion on the committee report? Seeing none, all in favor of the committee report, say aye.
Aye.
All opposed, no. The committee report has been adopted. To the bill. Senator Stedman.
Thank you, Madam Chair. Colleagues, Senate Bill 158 arises out of last year's experience with recall elections targeting members of the General Assembly. And as most of you are no doubt aware, last year was the first time in our state's history that sitting members of the General Assembly were recalled from office by the voters in their districts. The election process last summer was not exactly something I think anyone would describe as smooth or ideal. In fact, 4 separate cases were litigated through the court system in order to clarify for the county clerks and the people involved in the recall process exactly how the laws were to be interpreted and administered in this situation. One of those court cases actually resulted in the state Supreme Court declaring unconstitutional certain provisions in our state constitution and in our state statutes. Senate Bill 158 repeals that provision in state statute that was determined last summer to be unconstitutional by the Colorado Supreme Court. It also fills in a number of blanks in the process that were uncovered through this experience, and it reorganizes the statutes to make them easier for county clerks and election officials to administer, putting things in chronological order of how you go through the steps of qualifying and putting together a recall election in the event that voters petition for and demand such recall election. Some of the other things we're doing here is applying the existing laws that we have on the books today for petitioning processes, laws governing paid petition entities, petition circulators. There were open questions as to whether those laws applied to recall petition circulators. We are clarifying that we expect these petition circulators to be governed by the same sets of laws that apply for petitioning a ballot initiative onto the ballot. For example, under existing statutes today, when a person collects petition signatures on a recall petition and they are getting ready to turn in their petition, they have to have a notarized statement at the back of the petition affirming that they complied with Colorado law and how they circulated the petition. Well, the wording of that affidavit process for a recall petition is different than the wording for the affidavits that are required on ballot initiative petitions. Senate Bill 158 syncs that all up and says they're all going to be the same. Because when you have 2 different sets of wording on affidavits, there's some indication that the legislature intends 2 different standards to apply to those circulators. We shouldn't. It's all First Amendment protected activity. You're petitioning, and you should be governed by a consistent, easily understood, and easily applied set of rules. Training that is available for initiative petition circulators should also be available and be no different for people who happen to be circulating a recall petition. We're syncing all of that up so there is consistency in the laws. I think this is just taking the experience from last year and making our laws more understandable for everyone involved, for the people exercising their First Amendment right to petition, for the clerks that are counting the petition signatures and administering the election, and for the voters that will be asked to cast a vote on these questions. Now, the most significant thing that's within Senate Bill 158 has to deal with the issue of the timing of the election, because as you recall from last summer's experience, litigation resulted in a court determining it was not possible to use mail ballots in recall elections. And that's because of certain deadlines that are expressed in the state constitution. It's a deadline for how far in advance you must submit your petitions nominating you as a successor candidate in order for your name to be printed on the ballot. That deadline proved unworkable because of how the court interpreted that. We have a solution to this situation. we are providing a definition to certain terms in the state constitution in Article 21, where recall is established as a constitutional right of the people. We are defining the term, the date for holding the election, because no definition exists for that term in the Constitution right now, and it is the prerogative of the General Assembly to define the words that are used in the Constitution, to give them effect, and to put in place voters' intent in establishing recall as a constitutional right and something that happens that can be triggered, and an election that results that can be administered, that voters can also exercise their constitutional right to vote in. By defining the term date for holding the election, we make the timelines work so that clerks have time to put together the ballots, mail them out, and people have an opportunity to vote in a recall election using a mail ballot. We are not shortening the time that successor candidates have to petition their names onto the ballot as successor candidates. They still have the same amount of time they would have under existing law. We're just creating a timeline that works for the way modern elections are administered in a way that maximizes opportunities for voter participation. Because these are constitutional rights that we're talking about when we're debating the issues around the process of administering a recall election. The right to recall an incumbent is established in our state constitution as a constitutional right. The right to vote is established in our state constitution and in the federal constitution as a constitutional right. And we are giving effect to these important constitutional rights. We are also, I would submit, doing so in a manner that is consistent with the directive in Article 21 of our state constitution that specifically authorizes legislation that may be enacted to facilitate the operations of the provisions of Article 21. I submit to you, colleagues, that that's the purpose of Senate Bill 158. This is a bill that harmonizes, clarifies, and syncs up existing election procedures with the language and the rights established in our state constitution to give effect to those provisions, to make it possible for county clerks to smoothly and efficiently administer this election in a way that maximizes voter participation by preserving the availability of mail balloting. That is, in essence, the sum of Senate Bill 158, and I would ask for your aye vote.
Senator Jones.
Thank you, Madam Chair. Members, as we all know, nobody benefits from chaos in elections, especially the voters, and that includes military troops overseas. For our democracy to work, we need every eligible person to exercise their right to vote. And that is true for constitutionally guaranteed recall elections. Senate Bill 158 syncs up old constitutional requirements with modern elections. This is the first time recalls have been used for the state legislature in Colorado, and we learned a lot. We learned that there were logistical nightmares, potential election decertifications, and part of the law was declared unconstitutional. One of the county clerks testified in committee that they thought people were disenfranchised. For instance, the statutes varied from the Constitution, such as the timing for the governor to set the election. Another problem was in Colorado Supreme Court case, only allowed those who voted for the recall to vote for a successor candidate, which is unconstitutional. In another court case, the time frame for submitting names for replaced successors did not provide enough time for mail ballots, the thing that our voters have become accustomed to in Colorado. Because of the timeline for the recall election is different than the other elections, because they didn't get their expected mail ballots, the recall elections were very confusing to voters, and many people did not participate. We've had mail ballots in our state in some form for 15 years. The public overwhelmingly likes them. So who's been hurt by not having mail ballots? Military troops overseas did not get mail ballots. Other people living overseas did not get mail ballots. The elderly did not get mail ballots. The disabled did not get mail ballots. Single parents did not get mail ballots. Busy workers did not get mail ballots. People with family responsibilities did not get mail ballots. Elderly people did not get their family ballots. Rural people and Coloradans in general. As a result, turnout was horrible. 21% of the people in the district in Colorado Springs voted, of the eligible voters, and in Pueblo was 36%. Those are about 20% lower than normal. I'd also mention that this bill is supported by the Bipartisan County Clerks Association. Their legislative committee voted for this. It takes a 2/3 vote for them to support, and there were no votes, is my understanding. There were no votes. So in conclusion, nobody benefits from chaos, especially the voters. This bill aligns the timeline for statutes with the Constitution in such a way that anybody who wants to vote can vote. I ask for a yes vote on the bill.
Further discussion on Senate Bill 158. Senator Cadden.
Thank you, Madam Chairman. We would probably agree with the bill sponsor that there was some confusion along the way because of I think certainly a serious indication by that bill, the amount of litigation that happened around this and 1303. We would probably not totally agree on whether the outcome was ideal. Just saying. Work with me here. The mail ballots have been certainly growing in the use and popularity, as one of the sponsors mentioned, by 15 years, but that doesn't mean people have been disenfranchised for the last couple hundred years, because they have not. They have not. If you think they have, should we be here? If the outcome of the elections hasn't been accurate reflection of the will of the people, should we be here? I disagree. For the last 15 years, this system has been growing, frankly, in some areas, I think, to the detriment of what the Constitution aims to protect, which is that civil right of the vote, to protect the vote. And we have had that discussion here year over year over year, protecting the right to vote. Because unlike any other right, if one of these is stolen from you, you can't get it back. If somebody steals your car, you might be able to get it back. It might be insured. If somebody damages you through something, through a civil action or a tort, you can be made whole. An individual can be made whole. But if there's ever any fraud in any election, there is no way to make any of us whole or all of us whole if elections are subject to fraudulent acts. And we've seen over the years how that opportunity to create fraud in elections has happened. 36% is a pretty good turnout on any given year. Our job is not, I don't think, to increase turnout as legislators. Our job is to protect the turnout. We are not the marketing arm of partisan political activities in here, though some days it feels like it, doesn't it? That's not really our role. Our role is to protect those who choose to engage and make sure that their vote counts. So to act as if mail ballots are the be-all and end-all of access to the polls is not accurate. It's not accurate. This body was warned year after year, attempt after attempt, as it tried to expand the access for mail ballots, that there were certain concerns. They were ignored. And just because the Constitution might be an inconvenient truth, it's still the truth. And changing that through a statute is not allowed. It's not allowed. The bill sponsor mentioned the provision in the statute in the Constitution that allows the body to draft legislation in order to incorporate the will of the Constitution to protect the people. That's true. But we're not allowed to distort it. We're not allowed to pretend it doesn't exist. If we were, would we still be having discussions about maybe trying to refer a measure? I would say that we wouldn't, because those discussions are happening. We want elections to be fair. We want the civil rights of those who exercise their right to vote to be protected. I think we all do. What we have highlighted over the years are the problems in some of the mail ballot proposals, and those came to light this summer. They definitely came to light this summer. Litigation, 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 confusion. But people have not been disenfranchised. You will hear on any given election that someone thought the process was great, that someone thought it was terrible. That's how it works. We've been trying to protect, especially protect the military members and those serving overseas by extending the deadlines where their ballots could be returned. But to just arbitrarily create a new statute that redefines what the Constitution says we have to do is not within our authority. And when we stood here, some of us in different ways, some of us stood here with the Chief Justice at an individual ceremony, others of us stood together and were sworn in to support the Constitution. We made a promise to the people that sent us here that we would protect the infrastructure and the process that created the opportunity for them to vote to send us here. That's our primary responsibility, protect the Constitution and those who it represents, not to distort the Constitution in order to effect a statutory change to something that was inconvenient for us. Inconvenient for us. Sorry, this is not about inconvenience. Let's keep working on this issue and find a way to refer to the people, ask them for their permission to change their Constitution. Remember, it doesn't belong to us. What does belong to us is the responsibility to protect it. That's all we own. I would ask for a no vote.
Senator Stedman.
Thank you, Madam Chair. Well, actually, colleagues, I would submit to you that actually one of the problems we're trying to solve with Senate Bill 158 has everything to do with inconvenience. Because we heard testimony in committee last week from voters with disabilities who testified about the inconvenience of trying to get to a special election polling place when they have become a permanent vote-by-mail voter because of their disability and their desire to participate in elections. I had letters sent to me by persons who were inconvenienced by attending the committee hearing in person because it would have required traveling to Denver, and these folks are not necessarily mobile and able to do things like that. And so they sent me a letter and asked me to read a letter in committee on Friday about how important the right to vote is to them and how mail balloting helps them exercise that franchise. This, I would submit to you, is every bit about making elections convenient. We've done a lot of work over the years to enfranchise citizens and make sure that their participation in elections is made possible and encouraged. We've done things like permanent vote-by-mail balloting. You know, years ago we liberalized the standards for absentee ballots. We have instituted early voting and multiple polling place locations, voter service centers. We've done what we can to make voting convenient because of a value that I believe we all hold dear, that participation by the citizens in our democracy is where we draw the strength for our democracy. And then when people are, when their votes are suppressed or discouraged or made inconvenient, the values that we hold dear are not championed. This is all about making our election process work smoothly for the clerks and the election officials that must administer the election, and making it convenient and accessible and possible for our citizens to vote in those elections. Now, one of the things that is particularly troublesome, and that quite frankly, Senate Bill 158 does not provide a perfect solution to, is the question of military and overseas voters. There are federal laws on this point. Now, I don't know that they apply necessarily to a state recall election, but we have state laws that also seek to enfranchise our overseas active duty military personnel so that when there is an election happening here at home in Colorado and people are being elected to represent them, they have an opportunity to have their voice heard and their participation in that election. The court rulings that resulted last summer really just rode roughshod over the opportunities for military and overseas voters to participate in those elections. This Senate Bill 158 is not a perfect solution. However, it creates a much more meaningful opportunity and timeline for those mail ballots to get to those folks, for them to actually cast their ballot and return it in time so that their voice is heard, so that their participation in the election results in the election of someone that represents them. That's what we're trying to do. We're not changing the standard for what starts a recall. We're not doing anything to impede the rights of citizens to initiate a recall process and circulate those petitions and set this process into motion. We are merely making the process something easier to administer for the election officials that, with their impartiality and their oath of office, have that charge of running smooth, open, fair elections, and for the voters that wish to participate in them, however inconvenient that participation may be. We can break down some of those barriers. We've done it over the years by changing our laws around when and how and who we allow to vote in elections. And I think this is consistent with that tradition of doing everything we can to ensure that our elections are open and fair and representative of the wishes of the people. That's why we've sponsored Senate Bill 158. That's why I'd ask for your aye vote this morning.
Senator Renfro.
Thank you, Madam Chair. First off, one of the comments by the sponsor about the need for this, there is a way, absentee ballots, and you did actually mention it there in a roundabout way, I think. Absentee ballots are a way that people that cannot get there to the poll or need a different way to do it, they're able to request that within this process. So I guess when you really look at this and try to sit back and digest what we're doing, the one thing that just keeps coming to my mind to compare this to is Common Core math in a lot of ways. When is an election day? What is an election day? Do we know what election day means? We're trying to redefine that, just like we do in Common Core math a lot of times of actually changing math. That's what this bill is doing. And it's unconstitutional what we're doing. Basically, when you look at this, the 15-day requirement in the Constitution, according to the sponsors, if this is enacted, the 15-day requirement in the Constitution is satisfied, but 15 days will not begin 15 days prior to election, but probably 15 days prior to the first day of balloting, which is probably 37 days, so 15 plus 22. But is that really election day? We're redefining election day here. And I don't think that's something we can do. That is unconstitutional. And this bill strives in all its efforts to avoid the term election day in what it does by using the final day of voting. I think there was a lot of questions asked in committee about what is election day? What day, or what are we talking about? And we all know what election day is. This bill is trying to confuse that and to change those rules. And the problem is when we try to define this in a different way, we're redefining election day, and this is unconstitutional. The recall from office section of our state constitution, Article 21, was adopted in 1912 as one of the first ballot measures adopted under the new initiative and referendum provisions of the Constitution. Our Section 4, Section 4 of that constitutional amendment ends with this statement: the article is self-executing, but legislation may be enacted to facilitate its operations, but in no way limiting or restricting the provisions of this article or the powers herein reserved. This self-executing language means that only definitions needed or permitted to be defined in statute are those left undefined, ambiguous or undefined. But date for holding an election, that's a singular noun. It's not plural. It doesn't mean a period. It doesn't mean a season. It doesn't mean days. It means day. It's singular. The day for holding the election. The 2013 lawsuit by the Libertarian Party upheld that 15-day rule for petitioning onto the ballot. And Judge McGahee talked a lot about self-executing within that in this section. He did not see any need to search the statutes for a different meaning of election day or the date of holding an election. He knew what that meant because our Constitution is explicit within that. If we want to change the state constitutional provision for recalling elections, then we need to refer a measure to the people. Or we need to have an initiative that would come through and do that. This is clearly unconstitutional, what we're trying to do within this bill. And with that, I would urge us to step back and consider that. Even get an opinion of the court into that manner, because it's obvious this is going to end up in the courts. In reality, I would urge us to not pass this bill today, number one. Number two, I think this is the opportunity for the governor to use that veto pen that he's talked about a little bit. This is a bad bill trying to redefine our elections. And you should ask yourself why. What is the real motive of this bill? Why are we doing this? Election date is very clear. Vote no on this bill.
Senator Lundberg.
Thank you, Madam Chair. The bill we have before us is, according to the sponsor, a bill to enable every voter to be able to vote. I agree. In every election, every voter should have the opportunity to vote. And I hope they do vote. That's essential for our Republican form of government. We are sent here by the voters. We want to hear from them. We want to follow their authority. They are the citizens who vest in us the authority. And every voter needs to have the opportunity to vote. And every vote they cast, and this is key, every vote they cast needs to carry that authority and have that validity. Now, we've seen several bills in this session and last session that are pushing everything to a mail ballot system. And indeed, I think the legislature thought they had it wrapped up that everything was going to be mail ballot until they hit a bump in the road called the Colorado Constitution that had requirements for recalls that make mail ballot systems impossible. Impossible. The bill before us today is to try to finagle around that. But I stand here before you today opposing this bill on for a couple of important reasons. One of which is it is a work around the Constitution. We should never work around the Constitution. If the Constitution needs changing, then let's change it. There are appropriate mechanisms in place, both through the legislature or through the citizen initiative process, as you just heard the previous senator remind us all about. That's the proper method, but I want to talk to you about the other aspect here, and that is every voter's vote should count. Every voter should have the opportunity to vote, and every voter's vote should count. But when you start sending out mail ballots in a wholesale fashion, which is exactly what this bill is designed to do, you start to dilute that. You start to take away the authority of those individual votes. You know, in a previous bill that dealt with this issue this year, one citizen came and showed 4 ballots that they were sent. 4 ballots that they got in the mail. Now, this particular voter had the responsibility of voting once. So I've got 3 more ballots here. What sort of integrity does that put in the voting system? And more importantly, what sort of authority does that then vest into each and every individual voter? If you voted legitimately and somebody else takes a ballot that they didn't have the legitimate legal right to vote with and votes, what does that do to your vote? It cancels it out. The election process needs to have the integrity that honors the sacred authority of each and every voter. Senate Bill 158 is to set up a system that puts more of this kind of nonsense into our voting system. Yeah, it works around the Constitution, and there are legal arguments that could say, well, maybe it's sort of kind of legal, and unfortunately the courts will most certainly have the final say. But regardless, when you go down that road of a all-mail ballot system where every name and address, a couple of these ballots were for people who had not lived in the home for many years, several election cycles, but the law said, send out a ballot because we've got an address. Nobody asked for it. They were voting citizens elsewhere. 158 perpetuates this system that takes the authority away from individual voters. That is not a responsible system. That's a sloppy, ugly system for which the voters have no confidence in. Go look at some poll on their confidence in us in the first place. Look at what they think of Congress back in D.C. It starts with whether or not they have the confidence that they voted them into office in the first place. Senate Bill 158 goes one more step down that road of taking the voting system and throwing it away. Vote no.
Further discussion on Senate Bill 158? Seeing none, Senator Harvey.
Thank you, Madam Chair. I'd just like to respond to some of the things that were mentioned by the proponents of the bill. The argument that was made is that the elections for these recall elections were chaos. And that's why we have to come forward to amend the Constitution via statute, because the recall elections were chaos. Why were the elections chaos? Were the elections chaos because the Constitution put in place a scenario that could not be met? A Constitution that's been in place for over 100 years created the chaos? Or was it statute that had been in place for 10 months caused the chaos? What caused the chaos? Was it the statute, the Constitution that said that the citizens of the state of Colorado have a right to recall those that have acted in a way against their constituents and has been in place for 110 years, or over 100 years? Or is it a statute that was put in place that was so poorly drafted and rushed through the process 10 months ago that caused the chaos? We have not always had all-mail ballots in Colorado. We've had it for 10 months. The proponents of this bill would argue that it's the Constitution that caused the chaos, and that the judge who ruled that 1303 that was passed 10 months ago was running roughshod over the will of the people. The ruling of the judge ran roughshod over the will of the people? That's why we're doing this? Because the judge ruled that the Constitution says what the Constitution says? And that regardless of what this body wants to say, it cannot overrule the Constitution of the state of Colorado? That's the arguments for why this bill is necessary. Remember 10 months ago, 1303, when that bill was going through the legislature, it was over 105 pages long. I offered over 50 amendments on this floor, asking for changes to make the bill work. The sponsor of the bill sat in that corner over there and would not come up and defend her bill or argue against my amendments, not once. Do you remember that? There was a typo in her bill. One of my 50 amendments was an amendment to fix the typo.
Let's talk about this bill.
And they would not allow that amendment. They said it was perfect.
Senator Harvey, to this bill.
And so this bill is trying to run roughshod over the Constitution, because that bill ran roughshod over the Constitution. It did not take into effect how it would impact the citizens' right to vote and their Constitution. And the argument for this bill is because the judge ran roughshod over the will of the people. Let me read what the judge said about Bill 1303 with regards to this issue of the Constitution. The absurd results here would be to ignore the clear language of Article 21 and let the statute control 1303 simply because it would be easier and more expedient to do so. But constitutional mandates cannot be ignored because of inertia from this body, nor can a constitutional mandate be ignored because it is supposedly archaic. In committee, we heard the clerk and recorder from Pueblo saying, this is over 100-year-old constitutional provision. It's out of date. Well, the Colorado Constitution is over 100 years old. So should we run roughshod over the entire Constitution because it's over 100 years old? The judge went on and said, if Article 21 stands in the way of the legislature's, I'll put in there, desires with 1303, considers the efficient way to conduct elections, the remedy is to repeal Article 21, amend Article 21, but not to pretend it does not exist. That's from the judge regarding House Bill 1303 and its impact on the Constitution. So this is a workaround to come to a way to implement 1303 in all mail ballots when it comes to recall elections. The remedy, the judge says, is to amend or repeal, but not to pretend the Constitution does not exist. What we are doing today with this bill, we are not amending the Constitution. Only the citizens of the state of Colorado can amend the Constitution. What we are trying to do with this bill is to run roughshod over the Constitution. I know we are able to make statute here, which is a very, very powerful honor that we have. But we are not endowed with the ability beyond that to amend the citizens' Constitution. This needs to go before the citizens of the state of Colorado for their vote. If we want to refer it, get the votes. If you want to petition on, get the signatures. But this is unconstitutional, the way we are doing this. It is unconstitutional to amend the Constitution without a vote of the people. I would ask for no vote.
Further discussion on Senate Bill 158. Seeing none, the question before the body is the adoption of Senate Bill 158. All in favor, say aye. Aye. All opposed, no. No. The ayes have it. Senate Bill 158 is adopted. Mr. Majors, would you please read the title to Senate Bill 115?
Senate Bill 115 by Senators Roberts and Schwartz and Representative Fisher and Quorum concerning procedural requirements applicable to state water plans.
Senator Heath.
Thank you, Madam Chair. I move we lay over Senate Bill 115 to the end of today's second reading calendar.
The motion is to lay over Senate Bill 115 to the end of today's second reading calendar. All in favor say aye. Aye. All opposed no. Senate Bill 115 will be laid over. Mr. Majors, would you please read the title to Senate Bill 161?
Senate Bill 161 by Senators Ulibarri and Johnston and Representative Hollinghorst concerning the modernization of provisions of the Uniform Election Code of 1992 that ensure voter access for eligible electors, and in connection therewith reducing the deadline by which a voter registration application must be submitted via certain methods, altering procedures pertaining to national change of address searches, allowing emergency ballots to be obtained for non-medical reasons, amending provisions relating to military and overseas voters, increasing the penalty for providing false residential information, and making the aiding or abetting the provision of false residential information a new felony offense.
Senator Ulibarri.
Thank you, Madam Chair. I move Senate Bill 161, the State Veteran Military Affairs Committee report, and the Appropriations Committee report.
To the State Veteran and Military Affairs Committee report.
Thank you, Madam Chair. The State Veteran and Military Affairs Committee adopted two amendments. The first is to ensure that if a voter drops off their ballot to a voter service and polling center not located in their county, that county should deliver their ballot to the appropriate county. And the second was ensuring that individuals serving on a canvass board are not held liable individually for any acts that were conducted in good faith in completing their service.
Further discussion on the State Veterans and Military Affairs Committee report. Seeing none, the question is the adoption of said report. All in favor say aye.
Aye.
All opposed no. The State Veterans and Military Affairs report has been adopted. To the Appropriations Committee report.
Thank you, Madam Chair. The Appropriations Committee added an appropriations clause.
Any discussion on the Appropriations Committee report? Seeing none, the question is its adoption. All in favor say aye.
Aye.
All opposed, no. The Appropriations Committee report is adopted. To the bill, Senator Ulibarri.
Thank you, Madam Chair. Thank you, members. Today, we're discussing the update to the Uniform Election Code of 1992, which is a standard procedure that we do nearly every year to ensure that folks have access to the polls, that individuals who want to exercise their ability to give voice in this democracy are able to do so in a fair and free way. I'll speak specifically to Senate Bill 161 and reference some comments and sentiments I think that were made earlier. And I do think it is a duty of our legislature, of this Senate, to ensure that every single person has the ability to vote who is eligible. Our country prides itself on being a Republican small r form of government where individuals have the ability to participate in their government. And the right to vote is foundational to our democracy. It is protective of all other rights, and our Constitution has been amended more times for no other reason but to protect our right to vote. This is an issue that has come up many times where individuals have been denied the ability, although given the stated right, the written right, but have been denied the ability to cast a ballot because of who they are. The reason why we have the Voting Rights Act, why we've seen constitutional amendments, and what we want to do with this bill is to ensure that every single person can actually vote, and that the process is fair and easy. Quick policy highlights of the bill. First, we want to ensure that elections are accessible to all eligible voters, that if you're over the age of 18, that if you are a citizen of this country and a resident of the state of Colorado, that you should be able to vote. This clarifies deadlines related to voter registration and indicates that if you register to vote 8 days before the last day to cast your ballot, you will have to cast your ballot in person at a voter service and polling center. You will be ineligible to receive a mail-in ballot, and that's because of the processing time it takes for the clerks to get those mail ballots back out to voters, and then those voters to get them back out to the voter service and polling centers. We also have maintained that the voter registration drives, the church groups or the nonprofit organizations that go out and register people to vote must turn in those forms 22 days in advance so the clerks have enough time to process those forms and ensure that voters are receiving their mail-in ballots. Next, we're also harmonizing the self-affirmation a person makes while registering to vote with the statutory residency requirements that we put into law last year, ensuring that the affirmation that they're making lines up, that when they swear and affirm that they're eligible to vote, that they're eligible to vote at their sole legal residence, and it's very clear that it is their sole legal residence, not the place where they intend to vote. Second, we want to ensure that voting is accessible to military troops who are fighting to protect our democracy. We're clarifying that any ballots that are cast in accordance with the Uniform Military and Overseas Voter Act, and that they are deemed timely and are counted pursuant to that act to ensure that all folks can have the ability to vote if they are serving overseas. We're also adding in a definition of covered family to include spouses and civil union partners who may have to be overseas as a condition of their service, that families who travel or are stationed with other families still have the ability to vote at home. And we also are allowing overseas and military voters to request ballots using the current electronic transmission process through Election Day, so they can actually request, so they have the same ability to exercise their right to vote. A little over a month ago, I also stood here and extended my hand to both sides of the aisle to work on the issue of voter integrity. We've heard claims of voter fraud and of folks who have tried to game the system. And so the last part of the bill, and I think perhaps the most controversial, is ensuring that we're avoiding fraud and making sure our election system is fair. So there are a few enhanced penalties in here that folks should be aware of. Number one, we want to make sure that it's a Class 5 felony to tamper with or open against the authorization of the county clerk a ballot box, that we don't want folks actually tampering with our election system. We also are enhancing the penalty for knowingly giving false information, for falsifying your voter registration. Right now it's a Class 6 felony, and we're moving that up to a Class 5 felony to ensure that if someone tries to defraud our system, that there are penalties and that we are holding those folks accountable for undermining our democracy. There's an additional penalty that we're adding in for those folks who knowingly aid or abet those who are attempting to commit voter fraud. The most popular example was a former member of this General Assembly who said, sure, use my basement so you can defraud an election and pretend that you live here. Doing that should be just as that undermines our system in the same way as someone who goes to cast a ballot by trying to stack the deck. That's fundamentally unfair, so we've also made that a Class 6 felony. And then finally, we're also eliminating the intent language that was so controversial last year and trying to go from a subjective standard of understanding why folks are eligible to vote and saying instead that it should be a more objective set of criteria. And so we have a clear statement taking out the intent to reside language and saying that this no is your sole legal residence, and then we have a list of indicia that are listed out in statute. Have you moved your things? Have you moved your family? Are you maintaining another property that you're calling home, that you're sleeping in every night, but just for the purposes of voter fraud, you're saying you live here? There's an example we've talked about at length here in this chamber. You don't have to hear it again, but that's what happened in the last election cycle. What we're trying to clarify is that you have made it your sole legal residence. So, when this bill came up, I just want to share some folks who expressed their support of the bill. We had County Clerk Wayne Williams come up and indicate his support for the bill because it helps to clarify many of the technical pieces of running an election, ensuring that all eligible voters have the ability to cast their constitutional, fundamental, foundational right to vote. We had a young man who had worked in doing voter registration. A young college student had waited until 7:30 at night to testify. He also came and shared his opinion. And we've also been working closely with the COVAIM Commission, which is the bipartisan commission that was initiated last year to ensure that we're implementing technical reforms, again, to safeguard our democracy. We've been working with the Secretary of State's office, the County Clerks Association. What we heard from the County Clerks Association, those who are entrusted with the ability to run our election system, is that they received all support votes in their committee, their association, in favor of the bill. There were a few abstentions, but no one in opposition, because this is about the technical maintenance of ensuring a fair election. I think that's something that we all would want to honor. With that, I ask for your support of Senate Bill 161.
Further discussion of Senate Bill 161. Senator Harvey. There is an amendment on the desk. Mr. Majors, would you please read L009?
Amendment L009 of Senate Bill 161.
Senator Harvey.
Oh, I'm sorry. Thank you, Madam Chair, and I would like to thank the sponsor for this bill. Many of the issues in this bill are items that I brought up in my 50 amendments last year on 1303 that we are now having to come back for a third time and try to amend. And many of these issues in this bill are dealing with those.
Harvey, could you move your amendment?
But we haven't got there yet. So I would move Amendment 009 to 161 and try to help the sponsor for a third time fix 1303. And this amendment simply says that, oh, you want to read the amendment?
We've read the amendment.
This amendment simply says that if a voter does not want to vote by mail ballot and they want to go to the voting centers, that they can get a separate ballot and vote on that ballot in a way that allows them to vote without having that ballot be traceable to them. We have heard testimony in numerous committees over numerous bills that state that and prove that anybody can go in and see how Ted Harvey voted if they want to, if they have access to the voting files. And I think that's inappropriate. Nobody should know how Ted Harvey voted. That should be a private and secret ballot, and this would allow that to happen for those people who want to go into a voting center and vote, that they would get a flat ballot that is not traceable to any numbers other than that I got the ballot. So that's what this amendment does, and I would ask for an aye vote.
Further discussion of Amendment L009. Senator Ulibarri.
Thank you, Madam Chair, and thank you to my good colleague from Highland Hills from Douglas County. Sorry, Highlands Ranch, not Highland Hills. Highland Hills is where I live. Come hang out at Waterworld. So thank you for this amendment. I will respectfully ask for no vote. And the reason being, when county clerks conduct a coordinated election, they will choose to use many different forms of voting equipment. They may use an electronic recording, an actual voting machine that has been certified and tested by the Secretary of State to ensure integrity in that voting system, to require a printed ballot for every potential voter that may go to a voter service and polling center, substantially may increase cost and change the way and the time of processing ballots. It doesn't do anything to ensure secrecy or change. It just asks for paper. And then folks have to be, every county clerk would have to be prepared for a paper ballot for every single eligible voter, rather than using the technology that's already been certified as private and secure. So again, I appreciate the intent. However, I think it belies the ability of county clerks to do their job well using the technology that they've already purchased.
Senator Harvey.
Thank you, Madam Chair. These have not been certified as being private and secure. They've been proven just the opposite on multiple occasions. These voting centers are already there. The ballots are already there. The clerk and recorders already have to go and get the correct ballot for the individual when they come in. That expense is not different. It's not more, it's not less with this amendment. This is simply saying that the ballots at the voting centers will be verified as not being secure and private. I think the arguments for being brought up against this amendment do not have any merit, and I would ask for an aye vote on this simple amendment.
Further discussion on L009. Seeing none, pardon me? Well, take a senatorial 5. The committee will come back to order. Senator Heath.
Thank you, Madam Chair. I move we lay over Senate Bill 161, and then I'll move we proceed with Senate Bill 151. So I would request that Senate Bill 161 follow Senate Bill 115 on second reading calendar.
Senator Harvey, could you withdraw your amendment so we can, please? Senator Harvey.
Thank you, Madam Chair. I withdraw the previous amendment. I'm not sure what.
L009.
L009.
L009 is withdrawn. Senator Heath.
Thank you, Madam Chair. I'll try again then. Thank you, Senator Harvey. I would move that we lay over Senate Bill 161 and put it at the end of the following bill, which will be Senate Bill 115.
You've heard the motion. All in favor say aye. All opposed no. We will lay over 161 one bill. Mr. Majors, would you please read Senate Bill 115?
That little motion book. Oh, no. But I'll do the motions. Okay. Yeah.
But he moved 115. I know, but he just now moved it. Can we do it? We'll be in a senatorial 5 one more time. The committee will come back to order. In order to do this in order, we will next take up House Bill 1149.
Yeah.
Sorry, ladies, 115 was laid over to the end. Mr. Majors, would you please read House Bill 1149?
House Bill 1149 by Representative Conte and Senator Marble concerning making acts related to the advertisement of children for the purpose of transferring their care to others, trafficking in children.
Senator Marble.
Thank you, Madam Chair. I move House Bill 1149, and I move the committee report.
To the Judiciary Committee report, please.
Basically, what the committee report does, it amends page 3, lines 11 and 12, and it changes the whole scope of the public medium. Before, it had stated that the public medium had to originate within this state. And taking out originating in this state, it leaves it open for public medium around the world. So we will have a better access to getting these people incarcerated for repurposing children. The bill itself, a little history on it. There are currently no restrictions on the practice of an individual advertising for the purpose of rehoming children, a process which informally transfers custodial rights and places children with alternative families. This process takes place without the oversight or approval of the judicial system, adoption agencies and service providers, and state agencies and regulatory authorities. Such children are often advertised on internet chat rooms as being available for rehoming. And they are sometimes exchanged with little more than an authorization given by a power of attorney.
Senator Marble, are you still on the committee report?
Well, this goes further than the committee report.
Okay, should we vote on the committee report?
That's right. I stand corrected.
Question before the body is the approval of the Judiciary Committee report. All in favor, say aye. Aye. All opposed, no. The Judiciary Committee report has been adopted.
Thank you.
You can finish with the bill now, please.
Thank you, Madam Chair. And the whole purpose of this bill is to be able to stop the rehoming of children on public mediums. A recent Reuters investigation found that these children were particularly vulnerable to placement in unsafe homes and environments, sometimes with pedophiles. And the ones that are the most vulnerable seem to be those children adopted from overseas that do not come with the birth certificate or a way to really track their origin. Such practices are an obvious possible means of rooting kids into child prostitution or trafficking rings. And what this bill does, currently child sex trafficking cases are difficult to pinpoint and prosecute. This bill will add to the toolbox of policymakers and law enforcement. This bill will make it a Class 6 felony to advertise children for rehoming or advertise services related to facilitation of rehoming, and will make it a Class 2 felony to receive children as a result of such advertisements.
Is there further discussion on House Bill 1149? Senator Newell.
Thank you, Madam Chair. I come and rise in support of this bill. And for those of you who don't know what rehoming is, it means that it's a failed adoption, or sometimes when you have a youth in foster care and you get a potential adoption, they adopt the child, and then they come with, as you can imagine, sometimes all kinds of problems with them, emotional, mental, and of course physical. And so they come with that trauma with them. They're not necessarily easy kids to adopt. And oftentimes the new parents are frustrated and can't handle it. And so they literally try to pawn off these children onto other people. And so that's basically what rehoming is or one of the definitions of rehoming, where you're having the kids go from one home to another. It could be from sibling, not sibling, a family or relative. Usually those are more successful. But when they are done in this fashion, with just literally advertising on the websites, it is just so traumatic for the children. And then they end up sometimes even more than once being rehomed. So that's what rehoming is, and I'm a strong supporter of the bill. And thank you, Senator Marble.
Senator Lambert.
Thank you. I have a question for the bill sponsor about this. When we had the disastrous hurricanes and things like that, especially in Haiti, there was a lot of volunteer support for relocating orphans in the United States, and really not done with government support. There were organized groups who went to find orphans in Haiti who had absolutely no means of food, clothing, shelter, or anything else, helped transport them to Florida, worked, I think, with U.S. Customs for their entry into the United States under federal law, which allowed for refugee reception in Florida. They paid for their transportation out here. And I'm a little concerned here about perhaps that some of the technical things here might actually make that a felony in Colorado, because some of the coordination for their reception involved emailing church groups discussions in and out of how we're going to receive them here in Colorado. When they actually arrived, I believe the governor and others took time out to go, meet people at the Denver airport, meet the children and so forth. And in almost all cases, I know there were dozens of children that were adopted, into American families. But I'm concerned about the maybe what advertising means, if we say even emails and so forth to coordinate these types of things might be considered a crime because it's expediting the actual reception. We also have, and I can't remember the name of it, but I think we have the largest charitable organization here in Colorado of any in the world that have been able to relocate basically orphans, refugees, children from throughout the world. There were a lot I know that came out of Iraq that were orphans and displaced. And I'm just concerned about if there's any restriction on that would prohibit nonprofit organizations, church groups, things like that. And would they have to go through a coordinative process with the government in order to do some of those activities that they typically do now?
Senator Marble.
Thank you, Madam Chair. In this bill, there is a section which definitely goes into what you're asking. And no, that rehoming is if a person within the state of Colorado has an adopted child from overseas, and then they want to put them on the internet to rehome them. They have to originate here in the state of Colorado. That's one portion of the question. The other is on page 3, from lines 23 on to page 4, or it kind of goes through all of the sections that do not apply, all of the people that do not apply, and that's employee of the State Department of Human Services, a county department of social services, or a child placement agency that is licensed pursuant to Part 1 of Article 6. It goes on, and it definitely exempts, those who you were asking about.
Senator Lambert.
And thank you, Senator, because this, unfortunately, didn't have time to totally review this before it came up, because the child trafficking is obviously a huge problem. I just wanted to make sure that there are exclusions that readily recognize adoptive agencies that are doing especially humanitarian replacement in among caring families, and I think this appears to do that, but it's obviously we need this kind of definition to define the lanes in the road here as to what is nefarious and what is legitimate and things like that. So thank you very much.
Senator Newell.
Thank you, Madam Chair. I might add that the purpose of the bill is to make sure you're right, Senator from Colorado Springs. You're right in that this is trying to stop the advertising from the nefarious people, but it does make sure that those nonprofit, in particular those nonprofit child placement agencies that are doing the home reviews and the assessments and the background checks, and they're all going through the adoption process correctly, it does not mean, it does exempt them. So they will be going through the regular system.
Senator Marble. Further discussion on House Bill 1149. Seeing none, the question before the body is the adoption of House Bill 1149. All in favor say aye. Aye. All opposed, no. Ayes have it. 1149 is adopted. Mr. Majors, would you please read the title to House Bill 1100?
House Bill 1100 by Representative Swalman, Pabon, and Senator Grantham concerning the use of title documents to give notice of characteristics of motor vehicles that affect a vehicle's value and in connection therewith making an appropriation.
Senator Grantham.
Thank you, Madam Chair. I move House Bill 1100 and the Transportation Committee report and the Appropriations Committee report.
With the Transportation Committee report, please.
Thank you, Madam Chair. We had 3 amendments in Transportation Committee. Colleagues, one, just simply removing a reference to the branding to odometers. It mentioned incorrect odometers. We actually already have
The odometer is covered in another definition of branding, so that was removed. It was actually creating more confusion than it was helping, so we removed that in one amendment. Another amendment moved or changed a shall to a may in regard to the documentation required for those that are selling parts for the a renovation or a rebuild of a vehicle, and the documentation that could be accepted by the director. It was changed from a shall to a may, just to give more leeway for what can or can't be used for the documentation on those parts. The other one was a reviser's amendment because of another bill that is amending a similar part of statute. We had to do a reviser's note or reviser's amendment if one passes and the other doesn't pass, or if the other one passes and this one doesn't pass. We had to cover that base just to make sure that that was covered depending on when they were signed, et cetera, if they both passed. So that is the Transportation Committee report.
Any further discussion on the Transportation Committee report? Seeing none, the question is the adoption of the Transportation Committee report. All in favor say aye.
Aye.
All opposed, no. The ayes have it. The Transportation Committee report is adopted. To the Appropriations Committee report.
Thank you, Madam Chair. The appropriations clause is already in the bill from the House side. We did have a small fix, though, from the Transportation Committee on the reviser's note, just to clarify it, that if one passes, the other one does not take effect, et cetera. So this just fixed the reviser's amendment from the Transportation Committee.
Senator Lambert.
Thank you, Madam Chair. And we did hear this in the Appropriations Committee, and just might say that the Appropriations Committee did a masterful job in amending the Transportation Committee report. Please vote aye.
Question before the body is the adoption of the amazing Appropriations Committee report. All in favor say aye.
Aye.
All opposed, no. We have adopted the Appropriations Committee report. To the bill, please.
Thank you, Madam Chair. The bill is it's about auto title branding, colleagues. A little bit of history on this. We've seen over the last few years with some of the tragic weather events in other states, particularly Hurricane Katrina, Hurricane Sandy, where we have seen a hole in our own statute and our own procedures here in Colorado, where Colorado has become a title washing state. No pun intended when it comes to flood titles. We have these vehicles, and you see them on the news floating down the Delaware River or down the Mississippi, and those cars don't just end up in a junk heap, they end up in states like Colorado. They are given flood titles in these other states, and they ship them directly to here. They retitle them here, and they are washed. They do no longer have the flood designation on them, that they were actually underwater. This state and Vermont have become dumping grounds for these kind of vehicles. This really came to bear this last year with the floods up in northern Colorado, where we saw our own situations where vehicles were seen floating down the stream. Those vehicles with this bill will no longer be able to be washed, so to speak, here in Colorado. Those designations will stick from other states into Colorado. If they were a flood damaged vehicle, they will remain so here in Colorado. Same thing with other sorts of branding, such as non-repairables, tampered odometers. If these are placed on the titles in other jurisdictions, they will remain so here in Colorado now, and close that loophole for the title washing. That is the essence of the bill, Madam Chair, and I would ask for an aye vote.
Further discussion on House Bill 1100. Seeing none, the question before us is the adoption of House Bill 1100. All in favor say aye.
Aye.
All opposed, no. House Bill 1100 is adopted. Mr. Majors, would you now read Senate Bill 115?
Senate Bill 115 by Senators Roberts and Schwartz and Representatives Fisher and Quorum concerning procedural requirements applicable to state water plans.
Senator Roberts.
Thank you, Madam Chair. I move Senate Bill 115 and the Agricultural and Natural Resources and Energy Committee report and the Appropriations Committee report.
To the Agriculture, Natural Resources, and Energy Committee report, please.
Thank you, Madam Chair. The Agricultural, Natural Resources, and Energy Committee report is a strike below and is what we, excuse me, basically worked off of in the committee. Long story short, last year, Governor Hickenlooper issued an executive order calling for a state water plan. The essence of Senate Bill 115 is to incorporate the legislature in the discussion and formulation of the state water plan, as well as a broader public process. In the Agricultural Committee report, you'll see that what we ask for here in this bill is recognition that the General Assembly is the body that determines water law in Colorado, that we want to engage the people of the state in a public dialogue regarding optimum state water policy. We certainly recognize the value and important work of the CWCB in helping to develop the state water plan, but we also think that the state, the General Assembly needs to be a critical component of that development, and we provide for public hearings in the water basins, matching up with where the roundtables are, both during the preliminary discussion of the state water plan and then when a draft is actually formulated.
Further discussion, Senator Schwartz.
And thank you, Madam Chair. I think what was important that with this opportunity that wasn't specified in the original executive order was, again, the opportunity for the General Assembly to have a role, and there wasn't a specific identification of the public engagement, simply reference to some ad hoc committees supporting the efforts of the CWCB. But it was very clear in the language that has been adopted that there will be the foundation to the plan, which has been, in fact, respected by this bill, is the work of the Interbasin Compact Committee as well as the roundtables, and that will remain fundamental to the development of the plan.
Any further discussion on the Agriculture, Natural Resources, and Energy Committee report? Seeing none, the question is the adoption of the report. All in favor say aye.
Aye.
All opposed, no. The Agricultural, Natural Resources, and Energy Committee report is adopted. To the Appropriations Committee report. Senator Roberts.
Thank you, Madam Chair. This just puts the appropriations clause into the bill.
Further discussion on the Appropriations Committee report. Seeing none, the question is its adoption. All in favor say aye.
Aye.
All opposed, no. The Appropriations Committee report is adopted. To the bill, please. There is an amendment on the desk. Mr. Majors, would you please read L004?
Amendment L004, Senate Bill 1.
Senator Roberts.
Thank you, Madam Chair. L004 is just a clarifying amendment that...
Would you move it, please?
Yes, I'm sorry. I move L004.
To the amendment.
Yes, it's a clarifying amendment on page 3. We had in the strike below reference on line 18 to the state water plan was not appealable to any judicial entity, and that actually didn't have any appropriate place in the bill. So basically, we're just removing that, reinforcing that the state water plan is only a policy, it's not a rule, does not have the force or effect of law. And I ask for the adoption of that.
Further discussion on L004? Seeing none, the question before the body is its adoption. All in favor say aye.
Aye.
All opposed, no. L004 is adopted. To the bill. Senator Schwartz.
And thank you, Madam Chair. Again, you have heard a general summary of what the bill does, but the goal is to actually engage the public, we feel, and the members of the General Assembly through a process that will be coordinated by the Water Resources Review Committee, that will, in fact, in coordination with the CWCB, the roundtables, have public hearings in each of the basins to hear the information that's being provided by the plan and to seek public input. And there is no intent. We did provide on each individual desk a copy of the Colorado Water Plan handout. That has a time frame on it, and that time frame has been spelled out in a pretty exhaustive way throughout this process. There is no intent on the part of the General Assembly to delay either the drafting or the review of the draft as this process moves forward. Just there were concerns that we might delay the development of the plan, and that would not be, in fact, the case given the provisions of the bill.
Any further? Senator Roberts.
Thank you, Madam Chair. The only thing I'd say is water is our most precious resource. Hopefully this bill will draw the interest, participation, and input of the public, but also every legislator here. As we all know, it's too late if you miss this dialogue. And apparently Senator Baumgardner has something to say, but I would just really urge support of this bill. Thank you.
Senator Baumgardner.
Well, thank you, Madam Chair. And I just wanted to ask the bill sponsors on page 4, when it talks about the Water Conservation Board submits a draft water plan to the committee. What committee? The Water Resource Review Committee?
Yes.
Okay.
Senator Schwartz.
And thank you, Madam Chair. The Water Resources Review Committee is going to act as more or less a portal for this process and the engagement of the General Assembly, both with respect to the outreach as well as addressing concerns of the members of the General Assembly.
Senator Baumgardner.
Okay, and thank you, Madam Chair. And so they'll report back to you, and then you guys, or whoever's on the Water Resource Review Committee, will basically decide if this plan's going to go forward, or you're going to present to the General Assembly, or somebody else will present to the General Assembly what you feel the best plan is going to be.
Senator Roberts.
Thank you. Yes, roughly that's true. And also, if you look on page 2 of the bill on line 40, any member of the General Assembly, so you don't need to be a member of the Water Resources Review Committee, any member of the General Assembly may make a request in writing to the chairperson of the Water Resources Review Committee to hold one or more hearings to review the plan. So we really want to be inclusive of the entire body of the General Assembly.
Thank you. Thank you.
Senator Zenzinger.
I rise in support of this bill. My experience with public involvement is that sometimes when we're putting together state plans, they take many years, a lot of people are involved, but the only people who really pay attention are the people that are at the table involved in the conversations. And so then when it comes time to take an official action, many members of the public were not paying attention to what was happening. And so I believe that any opportunity in which we're encouraging more public participation, in which we are offering a hearing of people to come together to figure out what the plan is a good thing. We learned a lesson on that regarding US 36. It was a transportation plan that had been in the process for 10 years, but when it came time to actually implement a portion of that plan, there were many people that had questions about it, had some misunderstanding about it, and so I believe that this just helps better communicate what I believe is an extremely important issue in Colorado on water, and so I am very supportive of this bill.
Senator Schwartz.
And thank you, Madam Chair. And again, I don't go anywhere without handing this out, whether it's a healthcare meeting or what it is. You're absolutely right. Like I like to say, you don't have to be a water buffalo to have an opinion about water. And we are seeing another effort to put the public trust doctrine approach onto our ballot. The public will weigh in. How can we make this plan relevant to as many individuals as possible? Appreciate the opportunity to be able to communicate with as many members of the public as possible.
Further discussion on this bill? Seeing none, the question is the adoption of Senate Bill 115. All in favor say aye. All opposed, no. Senate Bill 115 has been adopted. Senator Heath.
Thank you, Madam Chair. I move that we rise, report progress, and beg leave to sit again.
The motion before this body is to rise, report progress, and beg leave to sit again. All in favor say aye. All opposed, no. The ayes have it. We will rise, report progress, and sit again.
So the script The Senate will come back to order. Senator Hodge.
Thank you, Madam President. We've had a number of bills under consideration. Please read the report.
March 27, 2014, Madam President, your Committee of the Whole Basic Report is under consideration. The following tax bills being second reading thereof makes following recommendations thereon. Senate Bill 158 is amended and 115 is amended, passed on second reading in order to gross placed on the counter for third reading, final passage. House Bill 1149 as amended, 1100 as amended, passed on second reading in order to revise, placed on the counter for third reading and final passage.
Consideration of resolutions. Mr. Majors, would you please read the title to Senate Joint Resolution 21?
Senate Joint Resolution 21 by Senator Todd and Representative Labuda concerning the recognition of National Women's History Month and in connection therewith designating March as Colorado Women's History Month.
Senator Todd.
Thank you, Madam President, and I move for the adoption of Resolution 21 and ask that it not be read at length, but would like to encourage all of our women legislators to join Senator Roberts and I in the well.
Senator Todd.
Thank you, Madam President. Today is a day that we are going to kind of pause and reflect a little bit on some of our women legislators. American women have played and continue to play a critical role in economics, culture, politics, and social in every aspect of the life of the nation by constituting a significant portion of the labor force, working inside and outside of the home as everything from educators and astronauts. American women have been leaders, not only in securing their own rights of suffrage and equal opportunity, but also in the abolitionist movement, the emancipation movement, the industrial labor movement, civil rights movement, and other movements that create a more fair and just society for all.
We wanted to point out that in
Senator Roberts.
Oh, I'm sorry, Madam President. But that's nice to be able to say Madam President. So thank you, Madam President. In 1893, Colorado was the first state to give women the right to vote through popular vote, and a year later, Colorado was the first state to elect women to the state legislature. Also, the first women elected to the Colorado General Assembly in 1894 were Clara Cressingham and Frances S. Clock, both from Arapahoe County, and and Carrie C. Holly from Pueblo County. And Carrie C. Holly has the distinction of being the first woman in United States history to initiate and get a bill passed. Colorado again this year has the highest percentage of women serving in a state legislature at 41%, while the national percentage of women legislators is 24.2%.
Senator Todd.
Thank you, Madam President. Such contributions and leadership in the areas that help women improve their lives and those around them led the United Nations in 1975 to designate March 8th as International Women's Day and led the United States Congress in 1987 to designate the month of March as National Women's History Month. And so today, what we are asking for all of you to join us with the 69th General Assembly to declare the month of March, even though we're here at the end of the month, as Colorado Women's History Month in recognition of the struggles, accomplishments, and contributions of American women throughout history. So with that, Madam President, I would ask that, no, you're going to do it. Sorry.
Senator Roberts. Madam President, we renew the motion to adopt Senate Joint Resolution 21 and ask for your support.
Any further discussion? Question for the body is the adoption of Senate Joint Resolution 21. Are there any no votes?
Yes.
With 35 ayes, 0 no, 0 absent, and 0 excused, Senate Joint Resolution 21 is adopted. Senator Todd.
Thank you, Madam President. And I do like the ring of that, Madam President. We would like to ask for the morning roll call to be added as co-sponsors.
Any objection? Seeing none, the morning roll call will be added as co-sponsors to Senate Joint Resolution 21. Mr. Majors, would you please read the title to House Joint Resolution 1009?
House Joint Resolution 1009 by Representative Williams and Senator Ulibarri concerning a request that Congress restore the Federal Voting Rights Act of 1965 as amended.
Mr. Majority Leader.
Thank you, Madam President. I move we lay over House Joint Resolution 1009 until April 8th.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. Let's see. House Joint Resolution 1009 will lay over until April 8th. Introduction of resolutions.
Senate Joint Resolution 24 by Senators Guzman and Aguilar and Representative Pabon concerning recognition of Cesar Chavez Day.
Mr. Majority Leader.
Thank you, Madam President. I move we lay over Senate Joint Resolution 24 until March 31st.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. Senate Joint Resolution 24 will lay over until March 31st. Consideration of governor's appointments, consent calendar. Mr. Majors, would you please read the appointments on the consent calendar?
Members of the Colorado Commission on Judicial Discipline for a term expiring June 30th, 2015, for terms Yolanda Regina Lyons of Monument, Colorado, to serve as a non-attorney and occasioned by the resignation of Albus Brooks, appointed for terms expiring June 30th, 2017. Richard O. Campbell of Denver, Colorado, to serve as an attorney, reappointed. Kathleen S. Kelly of Meeker, Colorado, to serve as a non-attorney, reappointed.
Mr. Majority Leader.
Thank you, Madam President. I move for the confirmation of all the appointments on the consent calendar, which includes members of the Colorado Commission on Judicial Discipline.
Any discussion on any of the appointments? Seeing none, the question is the confirmation of those appointees to the Colorado Commission on Judicial Discipline. Are there any no votes on any of the appointments? With 35 ayes, 0 no, 0 absent, and 0 excused, Yolanda Regina Lyons, Richard O. Campbell, Kathleen S. Kelly are confirmed to the Colorado Commission on Judicial Discipline. Consideration of governor's appointments. Senator Aguilar. Mr. Majors, would you please read the appointments to the Solid and Hazardous Waste Commission?
Member of the Solid and Hazardous Waste Commission for a term expiring August 1st, 2016, Randall Mack Weiner of Boulder, Colorado, to serve as a member of the public and as a Democrat, appointed.
Senator Aguilar.
Thank you, Madam Chair. I move for the appointment of Randall Mark Weiner to serve as a member of the public and as a Democrat to the Solid and Hazardous Waste Commission.
Any discussion? Senator Lumbert.
Thank you, Madam President. Members, this was the appointment that was laid over a few days, and so the discussion was a while back. I want to refresh your memory before we cast our vote for or against the governor's appointment for this gentleman to the Hazardous and Solid Waste Commission, I believe it's called. There were 3 gentlemen who were considered in committee, and 2 of which were unanimously approved and put on the consent calendar. But the question came up concerning the cost of dealing with waste management. And I'm the one who posed the question to all three gentlemen. The other two acknowledged that, yes, cost benefit is an element of considering policies dealing with waste management. But this gentleman resisted giving a clear answer that would indicate that he wanted to take into account the cost and the cost benefit of waste management. The best answer I got from him, if my memory recalls correctly, was sometimes it's going to cost a lot of money. Well, that's correct. Sometimes things cost a lot of money, but that's how we get into trouble around here, is we put people in charge of decision-making processes that don't truly and fully appreciate that sometimes it costs too much, whatever it is. And I want members of the Hazardous and Solid Waste Management Commission to take the whole picture, which includes what does it cost. And what I heard and what I determined from the attitudes I received was not satisfactory. I recommend that we defeat this measure, this recommendation, and tell the governor, let's find somebody who will take into account the cost of waste management, in addition to all the other factors that are so necessary. Thank you.
Any other discussion? Senator Hill.
Thank you, Madam President. Colleagues, as we did mention earlier in this week, we deal with a lot of complicated issues in here. There are always multiple sides to every single issue. Otherwise, there wouldn't be multiple sides in this chamber. Otherwise, we wouldn't have elections. Otherwise, we wouldn't have recalls. Otherwise, we wouldn't have this constant debate on so many issues. And that's the role of a public servant, is to step in and balance the different sides, to understand the different sides. And after hearing testimony from Mr. Wiener, colleagues, I was disappointed that here was someone not interested in coming and bringing the different sides of an argument together to understand how do we enact good public policy that serves the best interest of the people of Colorado. Rather, he brought a personal political agenda, and that seemed his role on this commission. And so I oppose his appointment to the commission. I certainly encourage those of you who value open discussion and understanding the different sides of every single debate that we have to say we need a better representative for the people on this commission.
The question is the confirmation of Randall Mack Wiener to the Solid and Hazardous Waste Commission. Are there any no votes? Senators Marble, Mr. Minority Leader, Senators Shuffle, Renfro, Grantham, Herpin, Brophy, Harvey, Lambert, Crowder, Baumgartner, Balmer, Hill, Lundberg, Roberts, Rivera, King. With 18 ayes, 17 noes, 0 absent, and 0 excused, Randall Mark Wiener is confirmed to the Solid and Hazardous Waste Commission. Signing of bills.
March 26, 2014, the President has signed Senate Joint Resolutions 11 and 20 and House Bills 1108, 1152, 1160, 1184, and 1265.
We'll take a senatorial 5. The Senate will come back to order. General order, second reading of bills. Senator Hodge. Or Senator Schwartz. You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The Senate will resolve itself into a committee of the whole for continuation of General Order, second reading of bills calendar, and Senator Schwartz will take the chair.
The committee will come to order. The court rule is relaxed. Mr. Majors, will you please read the title to Senate Bill 161? Mr. Majors.
Senate Bill 161 by Senators Ulibarri and Johnson and Representative Hollingworth concerning the modernization of provisions of the Uniform Election Code of 1992 that ensure voter access for eligible electors and in connection therewith reducing the deadline by which a voter registration application
Senator
must be submitted via certain methods, altering procedures pertaining to national change of address searches, allowing emergency ballots to be obtained for non-medical reasons, amending provisions relating to military and overseas voters, increasing the penalty for providing false residential information, and making the aiding or abetting of the provision of false residential information a new felony offense.
Senator Ulibarri.
Thank you, Madam Chair. I renew my motion to move Senate Bill 161.
Is there any further discussion of Senate Bill 161? Senator Harvey.
Thank you, Madam Chair. I again move Amendment 009, the best amendment of the day.
The further discussion of motion, Amendment 009. Senator Ulibarri.
Thank you, Madam Chair. And I again, I first want to say thank you to my colleague who gave us some opportunity and space to review the amendments and try and understand them a little bit more. That is helpful to do the background. So what I want to say again is, unfortunately, although...
Excuse me, Senator Ulibarri, I'm just one, sorry, we're going to ask Mr. Majors to please read Amendment 9.
Amendment 009 to Senate Bill 161 by Senator Harvey, amendment printed bill page 1.
Senator Ulibarri.
Thank you, Madam Chair. So what I want to say is that this amendment, I'm going to ask again for a no vote on this amendment, and after having some time to do some research, this is the reason why. We already have provisions that outline privacy protections to ensure that all ballots that are cast are private. And then just two quick cites, that's constitutionally mandated, and Senator Heath will talk about the other statutory framework that we've put in place that many of our colleagues who have served for many years have already supported. Article 7, Section 8 of our state constitution outlines that all ballots cast must be private. And then in statute, in 1-5-102.93J, indicates that all voter service and polling centers must make original or replacement ballots available. And that may not have happened last year, and I want to say that, but that has been an error that's been corrected, and that folks are offering original or replacement ballots. And so the intent of the amendment is already covered in statute.
Further discussion of Amendment 9. Senator Harvey. Senator Heath.
Thank you, Madam Chair. In a past life, I chaired the State Veterans and Military Affairs, and in that capacity, I ran Senate Bill 12155. It was a bipartisan bill. It was done with Senator White and Representatives Court and Murray in the House. And it was a bill that we spent considerable time and energy on and spent a lot of time with the clerks. And just so you all know, the bill was titled Concerning Procedures to Protect Transparency in Elections while Preserving the Integrity of Ballots in Connection with the Request for Public Inspection of Ballots under the Colorado Open Records Act. So the sponsor of this amendment is obviously concerned, as we were then, as to, and for the purpose of maintaining privacy in your ballot that you cast. And we certainly all agree with that. And that's why we spent a lot of time with this. And just going to a quick summary of the bill, one of the major points was that the designated elected official is required to cover or redact, based upon the most practical means available, any markings or message on a ballot that may identify the particular elector who cast the ballot before the ballot may be made available for public inspection. That was obviously to take care of the very situation that is being raised here. We also were concerned about elections where 10 or fewer people were voting, whether that was military voters or any special category, and we basically said if there were 9 or fewer ballots cast among all in that same election, which obviously would be easier, we said they had to be thrown back into a larger grouping so that you could not identify who voted in that very small cohort. And that they had to be presented for inspection in a random order. So this is a critical question, and I certainly appreciate where the sponsor of this amendment is coming from, but I believe it was dealt with by this body in Senate Bill 12-155, which obviously remains in force today and which requires the clerks to do exactly what 12-155 does, and that is designed to protect the anonymity of the voter.
Further discussion of Amendment 9? Senator Harvey.
Thank you, Madam Chair, and I think I caught most of what the Majority Leader was saying. One of the main issues around why this amendment is important is because there are counties that even when you go in and you vote at the voting center, you still have to put it in an envelope and sign the envelope and say, "This is my ballot." And that is one of the problems that we have seen around the state, not in every county, but those counties that do use an envelope, is that when the election judges open up that envelope, they can see Ted Harvey's name on the front of it, and they can see Ted Harvey's ballot. And that in and of itself makes that ballot insecure, and you have the ability to know who voted what and how they voted. But I also, as I explained earlier, there is identifying information on each of the ballots that is traceable. Though the argument is that it's not, it has been proven that it is. So in addition to the envelope having your name on it and the election judges being able to look and know who you voted for, they're also able to track down via the stub on there how you actually voted, and they're able to do that for 2 weeks after the election. I don't believe that's appropriate. I would hope that you don't either. I would ask for an aye vote on Amendment 009.
Further discussion, Amendment 9? Seeing none, the motion before us is the adoption of Amendment 9. All those in favor say aye. Those opposed, say no. No. Amendment 9 fails. Senator, no. There is an amendment on the desk. Mr. Majors, would you please read Amendment 13?
Amendment L013 to Senate Bill 161 by Senator Harvey, amend printed bill page 21, line 21, after person and...
Senator Harvey.
Thank you, Madam Chair. Though we didn't have the reader read this, I will. I move Amendment 013 to Senate Bill 161. This bill says, before providing the replacement ballot to the authorized representative, this is if you go in and you don't have your ballot with you and you want to vote at a voting center, the replacement ballot to the authorized representative, the clerk and recorder or designated election official shall match the signatures of both the elector and the authorized representative with those who contain the statewide. So if you go in and you have a designated election official sign off on the ballot that you are getting to help you with that ballot, we want to make sure that that individual is also a registered elector in the state of Colorado and is traceable on the score system. And the reason why is because there have been numerous cases of voter intimidation where you have individuals that live in public housing and individuals are saying, we want to pick up your ballot. Those individuals are feeling intimidated by having somebody come to their door and say, give us your ballot. I don't think it's appropriate for the state to set up a situation where voters are feeling intimidated. This says that if you are going to go and say you are picking up these ballots, that you are a registered elector in the state and that your name has been signed off on and been checked per the voter files to make sure you are at least legally able to vote in Colorado and you are who you say you are. So that's what this amendment is, and I'd ask for an aye vote.
Further discussion, Amendment 13. Senator Ulibarri.
Thank you, Madam Chair, and thank you again to the sponsor of the amendment for bringing it and giving us some time to understand. The authorized representative is an idea that we've put into election code to ensure that family members can help other family members, especially those who, for whatever purpose, are unable to go out and vote on their own. Maybe they are disabled and can't leave the home. You can think of this as the 16-year-old grandson, maybe, who has the ability to drive and wants to take grandma's ballot to the drop-off location. What this would do is say that the 16-year-old who wants to help grandma can no longer do it because the 16-year-old cannot be a registered elector in the state of Colorado because of age. It also means that if there's a home care worker that is helping someone who is living at home and unable to leave and they mark their ballot and they sign it and they vote it the way they want. That may be a home care worker who, for whatever reason, decides not to register to vote. Maybe it's because they've lost faith in our political system, or they don't like the choices that they're presented with, or just have not had time to register because they're worried about raising their kids, that they would be ineligible from delivering ballots. It is a narrowing that I think goes against the intent of allowing folks to deliver ballots because it's about ensuring that every single person can cast their ballot and not putting additional requirements on those folks who have assisted those family members to cast their ballots. So again, colleagues, I ask respectfully for a no on L013.
Senator Harvey.
Thank you. So the sponsor's argument is that we have to allow people to have who have the intent to vote to be able to choose who they want. And I would agree they should be able to choose who they want. And if they want to abide by the law with this amendment, they would find somebody who is a registered elector in the state of Colorado to be able to do that. As it is right now, you can ship in union workers from Chicago and go around and collect those ballots and go to people's homes and say, you have to fill out this ballot. And you can go to your union members' homes if you know who the union members are, and you send your union representatives to their home and say, fill out the ballot and we'll take it in for you. Where's your ballot? Fill it out now and we'll take it in for you. Are we really wanting to put in place a statute that says that we are going to encourage voter intimidation and forcing people to vote on a ballot that they may not want to vote, and saying that this individual can do it without being checked and without being an elector in the state of Colorado? I hope not. This is a reasonable amendment, and I would ask for an aye vote.
Further discussion of Amendment 13? Seeing none, all those in favor of Amendment 13 say aye. Aye. Those opposed say no. No. Amendment 13 fails.
Doing 12 next?
There is an amendment on the desk. Mr. Majors, would you please read Amendment L010?
Amendment L010 to Senate Bill 161 by Senator Harvey, amend printed bill page 19, strike line 10.
Senator Harvey.
Thank you, Madam Chair. Voters of America United. That's what this amendment is.
Move the amendment, please.
I move Amendment 010. This simply says if you do have that union worker coming to your house to pick up your election ballot, that they have to sign the outside of the ballot and say, yes, I am Ted Harvey and I want John Doe to be able to take my ballot, and sign it and date it. And so if we're not going to at least verify who these individuals are, we should at least be saying that the person signing the ballot authorizes the individual and knows who the individual is and allows them to do that. And that's what Amendment 101 is, or 010, and I would ask for an aye vote.
Further discussion of Amendment 0. Senator Ulivari.
Thank you, Madam Chair. Again, colleagues, I respectfully ask for a no vote on L010, playing out the scenario that we've discussed before of family members assisting those who are ineligible or unable to go to the polls on their own. This is an additional barrier. My concern, too, is if this is not filled out correctly and little Johnny, who's 17 years old and wants to take grandma's ballot to turn it in, and this is not filled in, if she voted her ballot, she signed her ballot, and it gets turned in, should it be then discounted because this requirement was not fulfilled? I think it's a way that we could potentially see voters disenfranchised when little Johnny, at the request of grandma, went to go turn in her ballot.
Senator Harvey.
Thank you. With all due respect, but grandma can write little Johnny's name on the ballot and say, little Johnny, would you go deliver this for me? Or you could have voter intimidation, where it's not little Johnny dropping it off. It is maybe the Public Works Department who owns and runs and manages the public housing and says, we want you to sign this document. If you want to continue to live here, you better vote for the mayor and the town council that we want you to vote for. And are you going to say that voter intimidation should be appropriate, or should we say that that voter should be able to sign on the line and say, I agree, I want this person to deliver my ballots? And I think that's the more appropriate way to do it, and I would ask for an aye vote.
Is there further discussion of Amendment 010? Seeing none, all those in favor of Amendment 10, say aye. Aye. Those opposed, say no. No. Amendment 10 fails. Mr. Majors, there's an amendment on the desk. Would you please read Amendment L012?
Amendment L012, Senate Bill 161 by Senator Harvey, amend printed bill page 13 after line 23, insert section 11 in color of our.
Senator Harvey.
Thank you, Madam Chair. I move Amendment 012 to Senate Bill 161. Members, when I voted on the last day of the election cycle, which would be Election Day, for those of you who don't understand what the last day of the election cycle is, it's Election Day, and I went to the polling place location to drop off my ballot, there was a ballot box out in a parking lot. And there were about 15 cars in front of me dropping off their ballots in a ballot box in the middle of a parking lot where you could drive up and drop off your ballots. Currently, state law says that grandson little Johnny can take grandma's ballot and go and drop it off without anybody knowing who little Johnny is and dropping those off. But he cannot drop off more than 10 grandma's ballots. So little Johnny can drive over to the drive-off ballot box in the parking lot and drop off no more than 10 ballots. But who is there to watch to make sure that little Johnny is only dropping off 10 ballots? Current statute says that it has to be manned if it's at a clerk and recorder's office, or that there has to be a camera on the ballot box. Well, I can assure you that the ballot box that I dropped off at, would be very hard to have a camera seeing how many ballots I would have dropped off, because it was out in the middle of a parking lot at the clerk and recorder's designated office location. And if there was a camera, it would have been on the other side of my car, because it would have been on the building that was the building office location where the parking lot was. So I would have driven up, the box was on my left-hand side of the driver's window, and the building was up here where the cameras were. Nobody would know how many ballots I dropped off. And if I was somebody, not little Johnny, grandson little Johnny, but I was somebody who was intent on voter intimidation, and I went to a public housing unit and I had them all vote in front of me, and I collected all of their ballots and took them to this ballot drop-off, there would be nobody who would be able to determine that I actually dropped off 100 ballots that I had intimidated people to fill out and sign, and drop them off, and nobody would be able to track it. This amendment simply says for all drop-off locations established under this section must be staffed at all times during which the ballots may be deposited. Must be staffed at all times. I think that's appropriate when we are talking about ballot locations that are out in the middle of a parking lot, that we at least have a little more security on who is voting, how they're voting, and how many ballots they are dropping off. And I would ask for an aye vote.
Senator Baumgartner. Senator Johnston.
Thank you, Madam Chair. One small factual correction. I do have a number of public housing projects in my district. I find the folks who live there to be not very easily intimidated. And so I'm not as worried about that. But I do think Senator Harvey raised a very important point here, which was the question of the security of those drop boxes. And so the good news is the Secretary of State has acted on this. There is both a statute on this and there is a rule on this. The rule is 7.5.1 if you care. The statute is 1-5-102.9. And it does specify what what the Senator from Highlands Ranch alluded to, which is that if you are a standalone Dropbox, then you are required by law currently for that Dropbox to be staffed every minute that it's open. So if you are like the red box of voting, then yes, you have to have a staff member that is there next to it every minute that it's open, observing everyone that drops off. The only cases where you can have the hybrid of either video surveillance or a staff member is at the actual offices that are attached to the county clerk sites. And so in those locations, you have either a staff member or you have video surveillance to make sure that you're able to monitor that. I will add the clarification, obviously. If someone drops more than 10 ballots, the crime is not by the people that voted those ballots. So it's not a question about you invalidate those ballots. The question is about how you enforce against the person that dropped them, which is why we're in the same spot you are if someone sticks up a 7-Eleven. Your challenge is to then use that video, use the other attendant data from eyewitnesses, license plates, all the rest. And I think those cameras are set up to capture both license plates as well as personal identity. So I think that Senator Harvey raised an important point. Good news is the Secretary of State's acted on this. We have both a rule and a statute to address it, so I'd ask for a no vote.
Further discussion of Amendment 12? Senator Harvey.
Thank you. If the Secretary of State has indeed done this by rule, then why would we be opposed to it? Because it would be doing what you say the Secretary of State's already doing. But I would argue they're not. They didn't make a rule. The rule was it has to be video surveilled, and like I said, there was no way from my position where the ballot box was out in the middle of a parking lot, any camera would be able to pick up how many ballots I dropped off. I think that's inappropriate to have that insecure of a voting location where anybody can come up and drop off as many ballots as they want outside of what the rule is. And let's explain why the rule is what the rule is. We say an individual can only bring 10 because it may be somebody that lives at a senior citizen home and they have 10 senior citizens that want to vote and they filled it out and they gave it to them. But it also may be a union worker who's going around and intimidating their members and getting more than 10 and saying, Vote this ballot, vote it now, and fill it out, and I will take it in and deliver it for you. And they may be intimidating a lot more than 10 people. There is a reason why in statute we say 10. I believe it should be 1. But previous legislatures have said 10. But if there is a 10 limit, then let's make sure that we are enforcing that 10 limit so that we don't have voter intimidation going on at the polling booths and that people are going around and getting more than 10 and turning them in. If we have it in the law, at least let's try to enforce it. I'd ask for an aye vote.
Further discussion of Amendment 12? Seeing none. All those in favor of Amendment 12, please say aye. Aye. Those opposed? Amendment 12 fails. Mr. Majors, there's an amendment on the desk. Would you please read Amendment L014?
Amendment L014 to Senate Bill 161 by Senator Harvey. Amendment printed bill page 23.
Senator Harvey.
Thank you, Madam Chair. This is another simple amendment that helps to solve some of the problems that we have in state statute, and so therefore I move Amendment 014 to Senate Bill 161. Currently in state statute it says that on election day, if you're going to register to vote, that you have to say that you lived in the district 21 days prior to the election. That's kind of vague. The Secretary of State's had some issues with that. Some clerk and recorders have had issues with that. What does 21 days before the election mean? So all this simply states is if there is a question about that, the question on election day or in regard to the election in which the challenged person intended to vote. So 21 days before the election in which they intend to vote is what we're talking about, not 21 days before when you lived in another precinct, another county, another state that you intended to vote, but 21 days before you intended to vote in this election. And so that's the amendment. I'd ask for an aye vote.
Discussion of Amendment 14. Senator Ulibarri.
Thank you, Madam Chair. Colleagues, I respectfully ask for a no vote on L014. And although I understand the intention or the stated outcome, the desired outcome of L014, I don't think it gets us where we would want to be to ensure that folks can vote and ensure that they're able to vote. This is something that came up with County Clerk Wayne Williams. Trying to dig in more, it sounds like the way that this is structured may cause more issues more problems than solutions.
Further discussion of Amendment 14? Seeing none, all those in favor of Amendment 14, please say aye. Aye. Those opposed, say no. No. Amendment 14 fails. Seeing no further amendments on the desk, is there any further discussion of Senate Bill 161? Senator Baumgartner.
And you know what?
Mr. Majors, there's an amendment on the desk. Would you please read Amendment L018?
Amendment L018 to Senate Bill 161 by Senator Baumgartner. Amendment printed bill page 24, line 13, strike.
Senator Baumgartner.
Thank you, Madam Chair. And first of all, I'd like to
say the magic words.
Move Amendment L018.
Thank you. Continue.
Thank you. And I want to step back just a little bit and first of all thank the good senator from Adams County. for being diligent in wanting to raise the penalty for fraudulent acts during voter or committing voter fraud or voter fraud on residency. But last year, this was brought up and was dismissed, and had several minutes on that, and that's why I'm complimenting this year. But what we did in this year's bill is we raised from a Class 6 felony to a Class 5 felony, which a Class 6 felony is 1 year imprisonment with 18 months, or up to 18 months in prison, and it moves it to a Class 5, which changes it to 1 year or 3 years imprisonment, which is the maximum sentence. So if we're really going to let the voting public know that we are taking into account that their right to vote is going to be protected, and that we're serious about the penalties that we're going to impose to dissuade people from voting illegally or from voting fraud, my amendment says on page 24, line 24, strike Class 5, substitute Class 3, so you go from 1 year in prison to 4 years imprisonment up to 12 years, which makes it very serious on voter fraud. And then we're going to change page 24, lines 21, from a Class 6 to a Class 5, which goes from 1 year to 3 years, because that is speaking to someone conspiring to help someone commit fraud. So I would ask for an aye vote on Amendment L018, because if we're going to be serious about voter fraud, then let's make the penalties serious enough to where people will know that we're not kidding at the state legislature when we talk about voter fraud.
Further discussion? Senator Ulibarri.
Thank you, Madam Chair, and thank you to the good senator from Hot Sulphur Springs.
It is.
Yeah. And looking at this, I just want to clarify what the bill does and why I think it's adequate as it is, and ask respectfully for a no vote on the amendment. We're moving up the penalty for lying about residency up from a Class 6 to Class 5 felony, and I grabbed the sentencing just so folks understand what that is and why this is such a serious change. So Class 6 felony is punishable by a fine of up to $100,000 and up to 18 months in prison. Class 5 is up to 2 years in prison, and it is a fine of up to $100,000. $100,000 fine plus 2 years in prison is a very steep penalty that has incredibly large repercussions for folks who may engage in that criminal activity, and I think serves as a large deterrent to engaging in voter fraud. In contrast, a Class 3 felony, maximum sentence, maximum fine amount, but we have to also look at the maximum fine amount, goes from $100,000 to $750,000. And the Class 3 maximum sentence is 12 years imprisonment, 5 years of mandatory parole. I think the fine we set was appropriate at $100,000. That's a large fine and would significantly deter all folks, and 2 years in prison is also a significant deterrent. I think moving even further down that road creates additional, I just don't think it's appropriate at this time.
Further discussion of Amendment 18? Senator Baumgartner.
Thank you, Madam Chair, and I appreciate the good senator from Commerce City's comments. But again, if we're going to make a penalty where people will not commit voter fraud, let's make it a penalty. And yeah, $100,000 that is a penalty. But if somebody's looking at 12 years in prison and $750,000 in a fine, that would dissuade people from even ever thinking about committing voter fraud. So again, I would ask for a yes vote on L018.
Further discussion of Amendment 18? Seeing none, all those in favor of Amendment 18, please say aye. Those opposed, please say. Amendment 18 fails. To the bill, is there further discussion of Senate Bill 161? Seeing none, the motion before us is the adoption of Senate Bill 161. All those in favor say aye. Aye. Those opposed? No. Senate Bill 161 is adopted. Senator Heath.
Thank you, Madam Chair. I move we rise and report.
Motion before us is to rise and report. All those in favor say aye. Those opposed? We will rise and report.
The Senate will come back to order. Senator Schwartz.
Thank you, Madam President. The committee has met and has had a bill under consideration. Mr. Majors, would you please read the report?
March 27, 2014, Madam President, your committee of the whole basically reports that in consideration of the following tax bills being a second reading thereof makes following recommendations thereon. Senate Bill 158 is amended, 115 is amended, 161 is amended, passed on second reading in order and agrees placed on the counter for third reading and final passage. House Bills 1149 as amended, 1100 as amended, passed on second reading in order to revise and placed on the counter for third reading and final passage.
Mr. Majority Leader.
Thank you, Madam President. Looking at the time, I believe it's pertinent to, so I move we recess until 1:30.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. The Senate will recess until 1:30.